Okay, so we're live. I wanted to see if I could change your name here. Escape this. Where do I do that?
Do you need me to change it? I can change it probably.
Oh no, I'm in there. So what should I put? Display name, attorney, and then put your company name?
Sure.
Lagerlof. Lager. What nationality was he? Lagerlof.
Swedish.
Okay, that makes sense.
Mm-hmm.
Lagerlof. Lagerlof Law Firm. Save. All right, got it. Okay, so we are, let me just double check here on Files Book. How is everybody doing today? It looks like we have one viewer. Okay. All right, so let's get started. I'm here with a new friend of mine, Joshua Driskel with Lagerlof Law Firm in Pasadena. And I recently came to know Joshua because he was the attorney on a real estate transaction. And anybody that knows anything about real estate, we always think, oh, great, let's just get an attorney involved. Here we go. I think I'd mentioned that to you. And it turned out to be a really pleasant experience. I felt like you operated just like a top-notch realtor would. And so it was just a wonderful experience. And so I then became to know you a little bit more and started researching your company and found out that you do a lot of stuff other than just, whoops, what happened? That you do more stuff than just transact in real estate, right? You do a lot of stuff. So why don't you tell me a little bit about yourself and your company?
Absolutely. So, as Teresa mentioned, we got to know each other on a recent transaction. And, I know anytime I get the call from the lender when we're doing this type of work representing buyer or seller, it's always to make sure that I'm not going to blow their deal up. And, thankfully, that didn't happen here. Teresa and I got to work together. It was really, really fun. Mm-hmm. But the type of work that I do on a regular basis, I do a lot of estate and trust work, a lot of, clients passing properties to their kids or just general, estate matters. A lot of real estate related transaction work, disputes as it relates to real estate, title issues, those kinds of matters, and then some corporate work. Corporate and tax. So we're really a full-fledged, business law firm. We've got just under 50 attorneys and about 100 total headcount. So if it's not me that does this work, it's somebody, on my team that can jump in and get it done. So it's a lot of fun.
When I was researching your company, one of the things, I love history. I'm obsessed with history. And on your guys' website, you had like this timeline of all the partners. And I think, like, when did your law firm start? Like in the late
1908. No, 1908.
1908. Yeah, 1908. And then it says you guys have over 1,000 years of combined attorney experience. So that's really something.
Yeah, no, we're one of the oldest law firms in LA County, which is where we operate. And really a deep history as it relates to this community and legal work and real estate and estate and trust, and that kind of work has been at the forefront of what we do here and has been since we started.
Wonderful.
So there's definitely a deep bench of knowledge, which is great. So if I don't know the answer, somebody knows the answer.
And then like another tidbit, so you too are a history buff and are. Tell me again what it's something with the Pasadena Museum of History.
Yeah, that's exactly right. So I'm a trustee with the Pasadena Museum of History, Pasadena's attic. And it's really essentially a great facility in Pasadena. There's a mansion property that is available for tour. There's a history center, and it really focuses on history of Pasadena, history of the San Gabriel Valley. And I've been on that board. Yeah, it's really great. Anybody that wants to go, reach out. I'm happy to connect you. Great local museum, and it's also the headquarters for the Tournament of Roses museum store. So if you're looking to buy anything for, Tournament of Roses related, or tickets to the parade or all that kind of stuff, you can do it at the museum, which is awesome, at their gift shop.
Well, I'm having you on today for 3 topics. One is going to be basically the transfer of real estate between family members, parent to child, child to parent, the tax consequences, why someone would use an attorney in lieu of a realtor in a real estate transaction. And then one that just came up was, I had some people call me recently. They had a friend that the mom wasn't doing so well. She had a large asset and nothing in place. And so they wanted to make sure that in the event of her passing, what could they do right away? Because they didn't have a trust, they didn't have a will.
Yeah.
So we'll touch on those 3 topics.
Great.
But first, let's go into the inheritance issue. It came on my radar last year because I voted for something, and I always read all of these bills, Joshua. Like, I get that pamphlet, I read them, and then I really liked the wildfire angle. I think it was like Prop 19, where they had said that when people are displaced, there were so many people displaced in Northern California that for them, if they were under 55, that they could keep their tax benefit. And that tugged at my heartstrings. And there were a couple of things in there that I thought were, pretty much normal. And for those of you that don't know, California has this really great thing that for people that are 55 or older, if you sell your primary residence and buy another primary residence, there's a tax basis exchange that you can do, which is really cool. And in line with that, what happened was, in that bill, somewhere tucked away, was taking away all of the Prop 13 rights between transfers of parents and children and future taxation. And I thought that was all the way eliminated, that you didn't have any more tax exclusion, until one of my friends, Johnny Shepard, had a situation he brought up to me. And I said, oh yeah, they did away with that. He checked with his attorney and they did not do away with it. So can you explain to my viewers that when you're inheriting a property or going to sell a property or transfer a property, what is going on with that right now, and what can people do to protect themselves?
Well, you're right in that Prop 19 really changed the law and the landscape as it related to property in California. It used to be under Proposition 13 that a parent could pass a property to their children, and if it was the primary residence, there was an unlimited exclusion for reassessment. For those of you maybe not in California, or even if you are in California, California's tax scheme as it relates to property tax is very different than many other places in the country. For California, right, the amount of tax is set at an artificially low level typically. It's only when a property changes ownership is the tax reassessed to fair market value. Many other places in the country, there's a routine and regular reassessment of property tax to kind of keep property tax in line with the value of property. California, that's not the case. Let's say that you bought a property in 1995 and you bought it for $200,000, and that's your assessed value for property tax purposes. Well, that $200,000 is only going to grow by a few percent each year, over what it was. So if you own a property 20 years, your reassessed value might be $300,000. Right. So, but maybe the value of the house is really 1.5 million at this point. Right. So you're paying tax on a much lower level artificially because California is keeping it low under Prop 13.
Got it.
Well, and it would only be if you changed ownership with that property did the property tax get reassessed, right? So if you sold that house to me for 1.5 million, I don't get to keep your $200,000 property tax. I have to pay it 1.5, right? So in the past, under Prop 13, you could pass that transfer. So if I was your child, you could transfer that house to me, and I would get to keep your same old property tax, the $300,000 or whatever it is. So much, much less, very expensive change, and so very much a benefit.
So on this $1.5 million example, you buy a house in California, it's taxed annually. The tax would be approximately $18,750.
Yeah, that's about right.
Versus a $300,000 house, the taxes would be, maybe like $3,000 or $4,000, or let's say $4,000, somewhere like
right.
that. Okay.
Exactly.
Now, if you are going to leave, I have a house, I'm going to leave to my sister. Is that a good chain, or does it have to be parent to child?
No, it has to be parent to child or grandparent to grandchild, assuming that the parent in the middle between grandparent and the grandchild is deceased.
So it's the child. So that's the link.
It's a child.
And
it's always been that way.
It can be child to parent.
It can be child to parent as well.
Okay.
Yeah.
So then I have this $1.5 million house I'm going to leave to my daughter. And I can give that to her now or when I'm deceased, correct?
Well, either way, you can give it to them now or you can give it to them when you're deceased. There's many reasons why you may not want to give it to them now that are outside the property tax realm. There's other tax reasons why you might not want to make a gift of it today and wait until you pass away. But you could, right? But under Prop 13, if it was your primary residence, it didn't matter if the house was worth $20 million, $5 million, or $20,000, it was excluded from reassessment. Now, under Proposition 19, it has to be the primary residence. So, I should add, with Proposition 13, you could do the primary residence at an unlimited level, but you could also do other property up to $1 million of assessed value and not change it.
Okay, got it.
Yeah, so think about it like, you have your primary residence, but then you have a triplex, right? And, that you charge rent on and all of that stuff. You could have gifted that property to them as well and kept that same property tax. Now you cannot do that. It's only primary residence. So under Prop 19, the new rules are primary residence of mom and dad or mom or dad to parent to child, right?
Okay.
And that's still an okay transfer. It does not generate reassessment so long as it was your primary residence and within 1 year of the gift or the transfer, it becomes the child's primary residence.
Got it.
So they have to
really
move
important.
in. That's a huge distinction over what used to be the case. It's also no longer unlimited. It's limited to $1 million. And the way that they do this analysis, let's go back to our example of 300,000 and now 1.5, right?
Got it. Okay.
So let's say that you are my parent. You're going to give me this property, and your tax basis, your assessed value is $300,000.
Okay.
And you give it to me, and the assessor looks at it and they say, okay, well, it meets the requirements of a parent-child transfer. All the forms are there. Teresa is mom and Josh is child, and Josh is claiming to be moving into the property or have moved into the property. That analysis is done. Check, right? Then the next thing they look at is what's the difference in assessed value. So if they look at the fair market value of the property and they say, okay, well, it's really worth 1.5 now, they will apply a $1 million credit against that property tax change. So the way that they look at it is if the swing in value between what the assessed value is and the fair market value is $1 million or less, they will allow you to keep the prior property tax. If the swing in value is $1 million or more, it's $1,001 or more, right? Okay. Then they give you the $1 million credit. So in this example, right, the house is worth 1.5, you have an assessed value of 300. There's a $1.2 million difference between those two numbers. So they would reassess the property to 1.2, and then they would subtract $1 million from that. So that would be my new assessed value.
Say that again. So current assessed value is 300,000.
Mm-hmm.
That's what the parent is paying, but the actual value is 1.5. So you took 1.5 minus the current value and then came up with 1.
Well, you would in effect have a tax reassessment of 500,000, right? Because they're just basically giving you $1 million credit, right? So that difference is 1.2. That's more than $1 million. So they reassess it to 1.5, then they apply the credit. So you don't get to keep. In this instance, I don't get to keep your $300,000 tax basis on a $1.5 million house, but I do get to get a $500,000 tax basis on $1 million house. So it is still a value. It requires a little more jumping through hoops, right? It has to be your primary residence, has to be my primary residence. If I ever move out of the house, technically I can get a reassessment, although we haven't seen the counties doing this yet.
So in my rudimentary sheet, your 1.5 million property, the market value is 1.5. You credit to $1 million. So then the tax basis is off $500,000 then is what the child is going to pay, right? 500.
Correct.
Pay assessed value. So we're at the 1.5, we said it was 18,750 at 500,000, just roughly 500 times 0.125 is 6250. So that would be 6250 tax amount.
Yes.
So it is, I mean, from 18, you're 18,750.
Still a savings.
62. It is good, but where you really get the shaft is if your parents or child, had some significant assets, or maybe had like a $4 or $5 million house. I know in Orange County, there's a lot of people trying to overturn this because that generational wealth they're having a hard time transferring that.
Yes.
Because it's a $4 million property. How are the kids going to be able to even keep it? So it's almost like a forced sale situation that's happening to people right now.
Yes, that's exactly right. And with the $4 million, example like that, I mean, in the past that would have been completely covered, no reassessment, all of that. And there are efforts to overturn this. I don't think there were enough votes or enough signatures on a ballot to get it on this November, but I think there's going to be more coming. The issue is I don't think there's been enough bad result.
People don't. They're not aware of it as much yet right now. I don't think.
Correct.
People,
that's right.
Just slipped it right in, and a lot of people didn't even know.
Well, most people didn't understand what it did, including the people that thought they did, right? And California Association of Realtors certainly put a lot of money behind Prop 19, and I think the reason for that was because it's going to result in a lot more sales. There's no doubt, right? Because people are not able to keep it.
Okay.
Yeah, they can't. The thing is, like, if you're, in the past, right, it almost always made sense to kind of keep the house that you inherited from mom and dad, rent it out because the taxes were so low. It was like free money. Now, if you're paying 20 grand a year in taxes and you're only making 25 grand a year in rent, it doesn't make sense.
Yeah. Now, I put this slide up on the screen where it talked about Prop 19 allows homeowners over the age of 55 to keep a better tax rate. And then we talked about the transfer of primary residence, that is the only way to do it. So if it's any other properties, you can't do that. And what does Prop 19 mean for inherited property? A child or children may keep the lower property tax base of the parents only if the property is a principal residence. Then the next one on here was, how does Prop 19 affect inherited property in a trust? Is there any difference if you're transferring this property in a trust, or any more advantageous?
No, not really. One thing that some clients do, a general revocable trust, like most people think of when they think of trust, does not have any kind of component here that would change this. The change is in potentially using LLCs instead of, you can use LLCs to kind of get around this in a few ways. It's not bulletproof. It does add cost and complexity, but there are options. And that, that's, people can certainly reach out to me. I can kind of go over that, but because it can get very complex in the way that we do it. But it is an option, utilizing an LLC potentially to avoid reassessment here.
Is there a benefit for people to, let's say you have elderly parents and they have a primary residence that that you're going to inherit. Maybe they have a will, but they don't have a trust. Is there an advantage to getting yourself added onto title now to just make sure that you have access to that property, or any benefit?
No, because it's going to generate reassessment now potentially. because unless it's your primary residence right now, you're gonna reassess 50% of it, even though mom and dad are still in there. So those are the kinds of results that I think people are going to start to see, and it's going to start to look at, and that's what we call like a poor man's probate. That's usually never advised anyway, to just add a child to title. One, because it changes the basis that child has in the asset, and it can make it more expensive when they go to sell it in the future because of capital gains, which are almost always more expensive than the increase in the property tax.
Okay.
So you don't want to trade one tax for a much worse and more expensive tax.
Okay. Well, I think that's all I have on that. So basically, it's not
big changes. You just got to be aware. Anytime a person or client is saying, "Hey, I'm just going to add my kid to title, or I'm going to transfer it to my child, or whatever," your antenna should be up. You should be thinking like, "Okay, well, wait a minute. You need to go talk to somebody, because this may trigger a reassessment that is unintended, and the assessor is not keen on reversing these." I mean, if you made the transfer, you made the transfer. Good luck getting them to to take it back.
LA County, I hate to say it, but gosh,
they're all bad. It doesn't matter if it's LA County or Orange County. I mean, it is the law of the land. Okay. Yeah, it's the law of the land at this point, and the assessor has limited ability to do anything.
Well, I like your advice where you said, and that's why we offer advice to a limit when it's legal stuff affecting, taxes, situations like that. We always tell people, you want to get an appointment with an attorney. And I think a lot of people are just kind of like, oh, they have a feeling like it would be so expensive. It, would be cost prohibitive. But what does it cost normally if somebody calls you up and says, hey, can I get on the calendar? I want to do a consult on, adding somebody to title. Like how much?
I mean, it's a minimal. I mean, you're talking a couple $100 for something like that, right? Even if there's even a chargeable event, sometimes we don't even charge for something like that if somebody just has a quick question. But generally speaking, right, I think there is it's worth it. Even if you spend a couple $100 talking to somebody like me and they advise you, hey, don't do this, you're about to step into a landmine. The $200, $300, $400, whatever it is, it pales in comparison to whatever the increase in property tax is going to be.
Got it. Okay. Well, thank you for all of that information. My name is Teresa Timms. I'm president of TDR Mortgage, and we like to have guests on that can offer insight and assistance to people when they're looking to do things with real estate and mortgages. So thank you so much for giving us all that great information. And if somebody wanted to contact you, Joshua, what would be the best way for them to do so?
They can always go to our website, email me, lagerlof.com, LAGERLOF.com. I'm listed there. Shoot me an email. I'm happy to talk about any of these issues and see how we can help.
Okay. I'll put that information in the video when we do that. And if you'd like information or assistance with mortgages, call or text 909-920-3500, and we are happy to help. Our next segment is going to consist of, I'm going to later kind of chippy chop this up and we'll do three different little segments. So that's why I kind of like at the end, I'm all,
no worries.
The next one, why don't we do, let me do this one right here, because this was a real-time example. I get a phone call. One of my past clients' mothers is taken ill, and she almost has this, $600,000-$700,000 house free and clear, no will, no trust, nothing, and they don't know what to do. And her condition may or may not be one where she has all of her whereabouts, her whereabouts,
wherewithal, whatever.
So I mean, I don't know. So my advice in a situation like that is you really need to talk to an attorney. First and foremost, talk to an attorney and find out what is the best course of action. I do know that if you just willy-nilly add people on the title or things like that, and they were found to be under duress, that the transfer or will or anything like that can be contestable. So I always refer them out. This particular situation, it was just sisters and they wanted to be added on title, keep mom on title. I helped them with a grant deed. I gave them information to talk to a local attorney. There's like one catty corner to my office, and they were in Fontana. So I just kind of thought it would be easier for them to come to an appointment here. I wanted to try to make it as easy as possible for them. And I also, told them everything that I know about it, but that I told them that really, really, really the best thing would be, to have a trust. And if little else, draft up a will, have it signed, have it notarized, do that right away. In light of that advice that I gave this particular person, tell me, what advice would you give someone like that? There are a lot of people that just, maybe they've never done a trust because they don't really know what a trust is, or a trust is $2,000 or $3,000 and their health directives in that. It's a lot of stuff getting that together. So what advice would you give to people out there that, maybe have an elderly parent that just, doesn't have their stuff together, and they know, maybe they're not doing well, and they just want to help facilitate the ease of all of that?
Yeah. No, well, I think that generally the advice you gave was good from the perspective of, trust first, will second if needed. And, typically we never say, hey, add them to title for a multitude of reasons, right? It could generate a reassessment for property tax. It could blow a tax basis for income tax purposes when there's a later sale. So it's usually not advisable to just add a child or anyone to title as a form of transferring assets upon death. It's not to say you can't do it. California does have actually a transfer on death deed that you can use. We don't typically recommend it for a couple reasons. It can be problematic just generally, and it's highly challengeable, and there's some other issues there. Typically, you are going to want to look at a trust, and a trust is really just a type of will that is much more, complex and a little bit, much more full ranging, in that it allows for it allows for transfer of assets upon death or incapacity, however the trust is structured, but it doesn't require probate like a will does. So wills always require probate. Probate's very expensive. It's time consuming. So let's say you spend $3,000 to $5,000 on a trust and the full estate plan package, right? There's very few probates that would be in that cost range. Even a $600,000-$700,000 house going through probate is probably going to cost around $12,000 to $14,000, depending on the time. Yeah, so it's a lot more to do in a probate than in a trust administration. So definitely advisable to look at a trust. If somebody has some capacity concerns, doesn't mean that you can't do any kind of planning. It just means that a competent attorney needs to analyze them, review them, and see what they're eligible to do. Okay. Because a client that has dementia or a client that has Alzheimer's, they may still be able to do some kind of estate plan or something like that. They just might not be able to do a complex trust. They might have to be limited to a will or something like that.
Okay. All right. Fair enough.
So definitely talk to an attorney that's familiar, because there are a lot of things that you can do and a lot of options.
Got it. Well, thank you for that information. We will drop your contact information, but if you just want to let everyone know who you are. I didn't reintroduce you at the beginning of the video. So this is Joshua Driskel, attorney, Lagerlof Law. Joshua, what all attorney stuff do you do over there?
Yeah, lots of attorney stuff. So if there's typically my clients are estate and trust related clients. They have, either significant assets or assets they want to transfer to their children. Sometimes those are lifetime gifts. Sometimes those are gifts at death. I do a lot of real estate related work, corporate related work as it relates to the estate plan. So, feel free to start with me. If there's something that we can do, I'll help you. If not, I'm happy to refer you out to someone that does do the kind of work you're looking for. It's a complex area. This is an area that's ever changing, moving. Usually the easy path results in some undesired consequences. So oftentimes we'll guide clients and make sure that they've gotten the right approach as to transferring assets or whatever they're looking.
Thank you. I like that. My name is Teresa Timms. I'm president of TDR Mortgage and Real Estate Group, and we serve the California market and beyond, and have been doing home loans in California since 1998. So if you're looking to buy, sell, or refi, pick up the phone, call or text to 909-920-3500. And remember to like and subscribe below. If you have any questions or comments, we'd love to hear from you. Okay.
Awesome.
Okay, this is last but not least, we are going to talk today with Joshua Driskel, attorney at Lagerlof Law in Pasadena, about why someone would opt to hire an attorney to represent them in a real estate transaction as opposed to a realtor. So I recently became friends with Joshua through a client that did just that. She's from the East Coast, and East Coast, we know a lot of attorneys represent buyers on the East Coast more so than anywhere else. And so it was just kind of a unique situation. And I was pleasantly surprised with how nice and normal it was. Because a lot of times you get, we have this fear of, you get an attorney involved and it's just going to be really attorney-ish.
Right. Really messy, expensive. We're going to blow your deal up.
Never going to answer the phone. Yeah. Blow your deal. There you go. All those things. Expensive, blow your deal, not be responsive. But you were none of those. So I thought, why not do a little segment about why someone would use an attorney in lieu of an agent? So Joshua, say hello and tell us why.
Yeah, absolutely. So you're right. It is much more common to see attorneys involved in transactions, Midwest, East Coast, for a multitude of reasons, right? Most of those states don't have escrow or even title in some instances. Attorneys might do the title reports and provide, kind of like a clean bill of, health on the title side. I'm from the Midwest. I'm licensed there. I've practiced there. So I've done these transactions there and here. But yeah, in California, right, we're blessed with, competent real estate practitioners. We've got escrow, we've got title, so you can certainly do it without an attorney, and most people do. Where attorneys come in, right, is in two instances: alongside the real estate agent and brought in by them, and I get brought in by real estate agents frequently. And it's when something gets a little bit more complex in a transaction, right? Maybe there's questions as to disclosures on buyer side or seller side. Maybe there's issues with, hey, we're hitting the notice to perform and they're still not responding. We don't want to click, we don't want to cancel, we want to force them to do something, or whatever the case may be, right? So we'll get involved there.
A real estate contract is just that, a legal, enforceable, binding contract. And if there's one thing I know about a lot of realtors is, they don't know contract law maybe as good as an attorney, right? That would be fair to say.
Well, they might know the car forms, right? If they're a California realtor, they'll probably know them very, very well. I know them well as, also. And, that's the great thing about California real estate is you can utilize those car forms and for the most part, not get into too much trouble, right? Because that's what they're designed to do, is kind of fill the boxes in, there's defaults and all of that. But there are often times where you need to determine what the contract's really saying, or there's a dispute as to what the contract's saying, or there's some other issue there. So we get involved there a lot. And that's, again, working alongside the agent. And I don't purport to say that we replace an agent at all. Like, I would never assist a client in marketing and selling a house. Never going to happen. That's not my area of expertise, right?
You're not going to go out with your listing presentation.
No. Yes. Can I put something on the MLS technically? Can I, have access to the car forms? Yes. Do I even use those often? Most of the time, no. But where we come in a transaction like this is where maybe you have buyers that are not using an agent, right?
Got it. A for
So
sale
you
by
might
owner, and that's
a
what
for sale
mine
by
was.
owner situation, right? That's what this was. And oftentimes these are people that are buying properties that maybe they were renting previously. Right. So this transaction that we worked together on was that, right? Our mutual client was the tenant. They wanted to buy the property from the landlord, and that's the transaction that we did. And I've done many of those, ranging in price from where we were in the 1.2s or 1.5s, whatever it was, to the $4 and $5, $6 million houses. The process is the same.
Okay.
And, there are agents that will write transactions up like this, represent both sides. They'll do it for 1% or something like that. I've seen that many times. We do the same thing. It's about the same cost,
Okay.
the 1% kind of range of the transaction volume, size. But you get the benefit of an attorney involved, right? And help you. And particularly if you're seller or sometimes buyer, I mean, it has value from the perspective of, okay, we make sure we're in good shape and we understand what we're signing and all that kind of.
I was going to ask you about the cost. So that we do see that very frequently, because you have a lot of obligation and liability. And if a realtor is representing the buyer and the seller, they're doing all the paperwork, they're facilitating the flow of all of that. Settling maybe like smaller disputes. When it's a for sale by owner, they've pretty much agreed and hammered out, what it is that they're going to do mutually. And then they have a previous relationship. So things are more easily solvable.
Yes.
So I feel like that's a pretty fair amount for that, as opposed to going through a realtor, listing it, for, 5%, 6% or whatever. Okay. Well, awesome. Thank you.
Yeah, and it definitely has, the pluses and minuses. I think the pluses are, the client gets the ability to, deal with an attorney that might be able to help explain some of that stuff that may be problematic for an agent, or when agent might not know. The minuses are, again, we would not do this. You would not use an attorney for a transaction which you're trying to sell to the general public. I just don't think they're equipped for that.
So in a situation where you have perhaps a contract dispute, I've found it very effective in the past where I've helped the agent, hey, go hire an attorney, fire off a letter and be like, look, section B, article, blah, blah, blah. You're, a nice legalese letter that's nice and firm sometimes, does the trick.
For sure.
Is how much does something like that cost usually, or it just depends on
it depends on the situation, right? I mean, it almost always the letter writing part of it is not the expense. It's sort of talking to the client and putting together what the approach is going to be, understanding what happened, what went wrong, right? Because the breach of the agreement or whatever the issue is pretty straightforward. Typically, it's like, well, they didn't close, or they failed to disclose this issue, or something like that. We get involved in a lot of failure to disclose cases, either on behalf of the agent, where the agent gets brought in on something, or just, the agent refers a client to us and says, our guy bought this property and they didn't realize that it, was built on an ancient burial ground and 10 people were killed inside, kind of thing. Not good. I have one right now. It's a failure to disclose case, and it's like a known gang house, and the seller was shot and didn't disclose it. Okay, that's a problem. That's something that would give, I think, a normal buyer pause, and something that the disclosures would pick up as to, any other issues that might cause a person to otherwise not want to buy this house. Right. Well, getting shot.
So this is no longer a gang house. Like, it didn't make a big sign out front.
It's like, oh my gosh. So anyway, things like that.
Well,
so we'll get involved
Joshua, your company, Lagerlof, is one of the oldest law firms in California. And you specialize in what law?
So I do specialize in estate and trust work, but I do a lot of real estate related work and represent brokers and title companies and escrow companies and transactions and buyers and sellers. We do a lot of work with agents throughout California, again, in like failure to disclose and those types of, issues. I love coming in and helping you keep a deal on the rails. I think it's that's great. And I'm happy to be a resource however I can.
And my name is Teresa Timms. I am the broker owner of TDR Mortgage, serving California, and we've been helping our California people since 1998, and we're happy to help in any way we can. If you're looking to buy, sell, or refinance, call or text today to 909-920-3500. Like and subscribe below. We want to hear your thoughts and comments, or if you have any questions and we can help, we surely will. Have a beautiful day. Thank you, Joshua, so much for your time today.
Of course. Happy to do it.
And that's the end of the video. Okay.
Awesome. This was fun. Thank you.
Yeah, it's not bad, huh? And then I'll send you, when I slice and dice these up and everything, I'll send you the little segments. And
oh, perfect. Yeah, I'll give them to our marketing person, make sure she's got them and makes good use of them.
Yeah, if you ever get the opportunity to.
Yeah.
Okay, so now what I do is, there's some comments here. I didn't see those before. Let's see.
Oh, cool.
Can you send me the information, please? So Rita is asking for some information. So is she on LinkedIn? Huh.
Yeah, it looks like
I didn't know that my live stream was working on LinkedIn. You have to I applied and did all this stuff, and it took like a year so that I could even be live on LinkedIn.
Oh, wow.
Yeah, kind of weird. And then there's a YouTube comment that came in 10 minutes ago. If the owner are foreigners, can they still use Prop 19 to transfer the property to their U.S. born children?
Yeah, it's not tied to citizenship. So yeah, they could. You know, if they own property in California, they can totally use that as a resource, no problem.
Oh, good to know. Okay, I'll go when I go on YouTube. So this video live streams on YouTube and saves as like one big video. And so I'll go on there and then put all your information and stuff in there. Oh, that's good to know. All right, I love it.
Awesome.
Okay, well, you have a great rest of the day.
You too. Thank you so much. I'll do this again with you anytime.
Okay, see you later.
See ya.